Good morning, all. Today's topic is understanding and interpreting a tax treaty. So, in this, the contents will include we will see about the introduction to a tax treaty, the principles of interpretation in the domestic law as well as the tax treaty. We have some interesting 2 3 case studies, significance of preamble in a tax treaty, aids to interpretation, most favored nation clause, and multilateral instrument. So we'll be covering the first 3 topics today and the remaining 4 topics will be covered in the upcoming session. So introduction to a tax treaty. When we see what is the introduction to tax treaty, we will cover the following subtopics under it. So what is a tax treaty or what was the main purpose of bringing the tax treaty? The main purpose was to eliminate double taxation and to avoid, we can only avoid to certain extent double non-taxation. So double taxation includes when a person, say for example, there is a person Mr. X, he is a resident of India. So if he goes to US and works there or do something, as he is a resident of India, global income will be taxable in India. So you will be paying tax in India on the income earned in US. And as per the US tax laws, you will be paying a tax there also. So this would lead to a situation of double taxation. So this was raising global concerns and it was becoming a matter of global concern because it was discouraging mutual trade and it was discouraging the multinational corporations to go into other countries, set up the business. So it was hindering the overall economic growth. So for this, the tax treaty, or it was also known as double taxation avoidance agreement or double taxation convention, was introduced, which is nothing but a written agreement between two countries. So it is a formally concluded and accepted agreement. It is based on negotiations between two countries to avoid double non-taxation and to eliminate double taxation. If it is between two countries, then it is called as bilateral treaty, and if it is between more than two nations, then it is called multilateral treaty. Because every nation has a right to tax its residents. So if it is taxing in the home country, it is an obligation. The tax is necessary for them. But in a host country, that is the source country, in our example US, it becomes a cost. So it becomes an unnecessary cost to the person. He's paying double taxation. He's paying the tax twice, in one US and in India. So this was the need for a tax treaty, and I hope you all know about the tax treaties and you're all what clear why the tax treaty was introduced and what is the meaning of the tax treaty. So what was the objectives of tax treaty? As I said, the main objective was to avoid double taxation and to eliminate certain extent double non-taxation. It was allocating the taxing rights to the TT party. If two countries are India and US, they have entered into an agreement, then they will mutually agree that these type of incomes will be taxed only in India or these sort of income will be taxed only in US. So it allocates the taxing rights between the two countries. And it helps in the prevention of fiscal evasion, that is tax evasion. It will also raise the tax revenue of both the countries without doing any unjust behavior. The treaties also contain provisions for exchange of information between the two countries, and it brings out a non-discrimination between residents and non-residents. So any person is taxed in the same way. There is also a dispute regulation resolution mechanism involved. It helps in collecting taxes and it is a equity and fairness. It is a just behavior. It helps in promoting mutual economic relations, trade and investment. Types of treaties, there are two types of treaties, limited treaties and comprehensive treaties. Well, limited treaties are less wider in scope, comprehensive treaties are more wider. As limited treaties cover only certain aspects of income, comprehensive treaties address all sources of income. So when we see what is the difference between the tax treaty versus the domestic law in every country, tax treaty it is a negotiation between two states. Wherever mentioned state here, it means a country. Whereas domestic law, it is the power of every sovereign nation to tax. So it is a decision of the independent nation. Two countries are not involved. It is an intention of only one country is involved. whereas in this tax treaty, intention of two countries are involved. And it is an international law, whereas domestic law it's conferred only to the is binded only to the domestic territories of the country. Tax treaty involves negotiation process, whereas domestic law doesn't involve any negotiation. It is an act of legislation under the constitution. And tax treaty tries to eliminate double taxation, whereas domestic law it just shows ways of charge of tax. Tax treaty is involved in sharing of tax revenue, and domestic laws are involved in earning of tax revenue. In domestic law, frequent amendments will be coming on. We see a lot of amendments coming in the domestic law, but in the tax treaty there are no frequent changes. In domestic law, a dispute is settled by the appellate forum or the court, and tax treaty there is also a procedure called mutual agreement procedure for settlement of disputes between the countries. So structure of tax treaties, how the tax treaties will be structured, it will be structured in the following way. The first is scope of convention, what or not it covers it will be involved. Then the definitions will come, then the taxation of income, taxation of capital, provisions for elimination of double tax, special provisions such as anti-avoidance provisions, miscellaneous provisions, protocols and termination. So this is just an example of India UK DTAA, how it is classified. How are the provisions classified? And these are the substantive articles. Now we move on to the next topic, principles of interpretation. How do we interpret a tax treaty? Interpreting a tax treaty involves we need to understand the intention of the lawmaker, and in the intention of two countries is involved. Whereas while interpreting a domestic law, we just see the intention of one country, that is the domestic country. And treaties often use some terms which are not used in the domestic law. They are more generally worded. They use more general terms. If we take those general terms and interpret as if we are interpreting a domestic law, it may be misleading and unsuitable. Because we have to interpret a tax treaty keeping an international law in mind, keeping the intention of the two countries is involved. And in some cases, the tax treaty may even lead to double taxation or double non-taxation if it is not interpreted in the right sense. When we interpret the domestic law, there are few rules and regulations. I think all are aware of it. The basic rule is rule of literal interpretation and purposive interpretation. Literal interpretation means we use the words as it is found in the legislature itself. We just take the ordinary meaning of the words. We don't go behind the words. To understand the intention of the lawmaker, we just use the ordinary meaning. Whereas rule of purposive interpretation, it is the modern version and it is more flexible than the rule of literal interpretation, where we go behind the original meaning of the words. It also allows the court to add or ignore words to help them give a decision which supports their view why this act was created. So we see the intention of the lawmaker. Azadi Bachao Andolan. It was a case going on between the Union of India and the Azadi Bachao Andolan in the Supreme Court. So the case was previously when Mauritius was a tax haven, it was a tax-free country. At that time, as per the DTAA entered between India and Mauritius, the capital gains of any resident of Mauritius by transfer of shares of an Indian company was taxable only in Mauritius according to the Mauritius tax laws, and it won't be taxable in India. And that time Mauritius was a tax haven. So the transfer of shares of Indian company were not taxed anywhere. This and all was before the amendment of section 9 and all, when the indirect transfer also was deemed to be an Indian income and taxable in India. So the issue was whether DTAA could override the income tax provisions and whether the CBDT also issued a circular in this sense that it won't be taxable in India and it will be taxed only in Mauritius, and Mauritius was a tax haven, so these income except tax. The result was many companies used Mauritius as a hub and invested in India through Mauritius. So many foreign institutional investors invested in India through Mauritius and they escaped tax. But the income tax authorities, there were many criticisms against the Indian government because of this, and many income tax authorities even issued notices to FIIs, that is foreign institutional investors, to pay tax on the income, that is on the income on the capital gains. So this led to a case, and the issue was whether DTAA can override the income tax provisions. There were three issues. First one was whether DTAA can override the income tax provisions, whether, and CPDT issued a circular that this is also valid. So whether CPDT has the power to issue such circulars, and whether the central government can enter into DTAA with any country and bring out such provisions. So it was in favor of the Indian government, and the DTAA, if it contains specific provisions, so it prevails over the Income Tax Act. And it was also concluded that CBDT has the power to issue circulars in this behalf, and the central government can enter into any agreement with a third party, with a country, as per section 90 of the Income Tax Act. So the capital gains of the Mauritius resident wasn't taxed in India, and it wasn't taxed in Mauritius also. That was a conclusion that time, but now it has changed. The DTAA has been changed, and now it is taxed in India also. So at that time, the Francis Bennion commented that interpretation of treaty imported into municipal law by indirect enactment. Words are to be given their general meaning, the meaning of the diplomat rather than lawyer. So the ordinary meaning needs to be taken. Interpretation to take care of consideration based on which treaty is negotiated and entered at a political level. So it is between negotiations between two countries. The intention of both the countries needs to be taken into consideration before interpreting a tax treaty. These are the important principles of international law applicable to tax treaties. Principles enunciated by the International Court of Justice. So international law is also applicable, and tax treaties are a legal obligation for the contracting states from the standpoint of public international law. So tax treaties are a legal obligation. It is a liability on the part of the countries contracting. That is the countries signing in it. They cannot escape from the tax treaty. And the binding nature of these principles on domestic courts depends on the rules of constitutional law. So there is this called VCLT, Vienna Convention on the Law of Treaties, 1969. So what is Vienna Convention on the Law of Treaties? It is an international agreement regulating treaties. It contains comprehensive rules, guidelines and procedures for how the treaties are drafted, amended, interpreted and generally adopted. It is also called as Treaty on Treaties. So it basically contains the framework on how treaties need to be drafted, amended, how the treaties need to work. It was adopted in and opened to sign in May 1969, and it came into force in January 1980. Till now, that is till January 2018, the latest data available, 116 countries have signed to the VCLT. So VCLT defines a treaty as an international agreement concluded between states in written form and governed by the international law. This Vienna Convention on the Law of Treaties has given some interpretation of treaties according to the Article 31, 32, 33, which we'll be seeing now. So VCLT is binding on the states that are signatory. That is, it is binding on the 116 countries which have signed the VCLT. But according to some case laws and some Supreme Court judgments, it can be relevant on non-signatories and can be applicable to both past and future treaties. The some of the non-signatories include India, Ireland, France, South Africa, etc. Now, what is the basic principles of Vienna Convention? Article 26. We will start from Article 26, that is Pacta sunt servanda, which says treaties are binding on the contracting state and they must be performed in good faith. The treaties should be performed by the countries in good faith. They should act in a honest and prudent manner. Article 20 is regarding the non-retroactivity of the treaties. As we saw in domestic law, many amendments came or keep on coming which have a retrospective effect. That is, it is applicable from the past date. But treaties cannot be amended in that way. Unless otherwise provided, it cannot say that it has a retrospective effect. Article 31 deals with the general rules of interpretation. A treaty needs to be interpreted in good faith. That is, the intention of the countries needs to be kept in mind and ordinary meaning should be given. So first we will give the ordinary meaning, keeping in mind the context and purpose and object. The context includes the text including preamble and annexes. What is preamble? It defines the scope of the treaty. So which we'll be seeing in the upcoming slides, and preamble we'll be seeing in the upcoming session. The context also includes the agreement relating to treaty made in past, instrument related to the treaty made in past and accepted by one or more parties in the past. In addition to the context, the following matters needs to be kept in mind. If any subsequent agreement between the parties has been entered, then the application of those provisions also need to be kept in mind. And any subsequent practice in the application of the treaty which establishes the agreement of the parties, these also needs to be kept in mind. The applicable rules of international law, as I said, it is governed by the international law. So the rules of the international law also needs to be kept in mind while interpreting a tax treaty. According to Article 31, first we need to give the ordinary meaning and then a special meaning also shall be given if it is established that the parties so intended. So the intention of the countries, if they intended that a special meaning needs to be given to these terms, then that meaning should be given. Article 32 gives the supplementary means of interpretation. It includes preparatory work of the treaty and circumstances of its conclusion. So, where Article 31 was giving the general rules of interpretation, that first we need to give the ordinary meaning and then the special meaning if the parties so intended. This involves, Article 32 involves the supplementary means of interpretation. That it includes the preparatory work. Why was the treaty framed for? What was the preparatory work going on? And what is the circumstances? If we interpret in this way, what conclusion we arrive? What are the circumstances we arrive at? So this and all needs to be kept in mind while interpreting a tax treaty. Recourse to this needs to be kept if while interpreting in Article 31, as we interpret, it gives a meaning which is ambiguous, not clear, or it leads to a result which is manifestly absurd or unreasonable. Then only we need to take recourse to Article 32. Article 33 deals when the tax treaty is interpreted authenticated in two or more languages. In India, this is not an issue because it is signed only in English language. Then the text is equally authoritative in each language unless the treaties provide so. So if it is signed in two or more languages, it is equally authoritative in two or more languages. If the text is authenticated only in one language, then that version of text will only be authenticative unless the parties otherwise provide for. The terms of the treaty will also have the same meaning in each language. When there is any mismatch between the terms in two or more languages, then we need to try to apply the Article 31 and Article 32 and remove the differences. Then also if we cannot remove, the meaning which best reconciles the text that having regard to the object and purpose of the treaty that shall be adopted. So we should try to at the best remove the differences while applying Article 31 and 32. If we can't remove the differences between two languages, then that meaning which best reconciles the text, keeping in mind the object and purpose for what the treaty was drafted, it shall be adopted. Article 3.2 is the most important article I can say in the tax treaties and in the OECD Model Tax Convention. While framing a tax treaty, there are three model conventions. Like basis on how the treaty needs to be framed, it is OECD, UN Model Convention and US Model Convention. So the OECD Model Convention in Article 3.2 says if there are some undefined terms, then it can be understood if there are some undefined terms in the tax treaty, then those meaning can derive, we can take recourse to the domestic tax law of that country applicable to the taxes covered in the treaty, and we can take meaning from the domestic tax law. So in this few case laws are also there, case studies in which states that meaning can be ascertained from domestic tax law when the term is not defined in the tax treaty. And if any notification is issued by the government regarding the meaning of the term, then that meaning can be taken for interpretation unless the context otherwise requires. So we have a very interesting case study regarding this Article 3.2. The facts of the case is there was a person, Mr. Fowler. He was a resident of South Africa for tax purposes. He went to UK and undertook some diving activities. He was a qualified diver and he undertook some diving activities. So it was assumed and it was presumed that it was the fact of the case that he undertook diving activities as a part of his employment and not as self-employed contractor, not as business purposes. And Article DTAA between South Africa and UK was considered. As per the DTAA, Article 7 was for business profits and it would be taxed only in the if we have a PE. That is, if he has a permanent establishment, only then it will be taxed in UK. Otherwise, he will be taxed only where he is a resident, that is South Africa. And as per Article 14, there is employment purposes. If he is there for employment reasons, then he would be taxed in UK. On the facts of this case, this looks like a simple case. But the issue was complicated by two issues. The first one was in UK, for domestic law purposes, for domestic tax purposes, the qualified diving activities were considered to be as a business profits. So I will first just explain the case law in a brief and then we will move on to the slides. So as I said, the issue was in United Kingdom, according to the domestic tax law, the diving activities were taxed as if it was self-employed and it was considered as business profits. And the second issue was the term employment was not defined in the treaty. In the tax treaty, the term employment was not defined, though business, enterprise, that and all were defined. But in the tax treaty, the term employment was not defined. And it was like we can take recourse to domestic law for terms undefined in the tax treaty. So what Mr. Fowler alleged that while taking recourse to domestic tax law, since employment is not defined in the tax treaty, as per UK government, it is not employment, it is business profits. And Mr. Fowler did not have a PE in UK, so it won't be taxed in UK. And it will be taxed only in South Africa. But the fact of the case was in South Africa, it would be treated as employment and the South Africa government, according to their domestic tax law, they gave relief to the employment to the people going outside for employment like that and it wasn't taxed in South Africa also. But the ruling didn't give weight to this point. The ruling gave to the weight to this point that whether it was considered as business profits or whether it would be considered as employment. Mr. Fowler alleged that it would be considered as business profits, and since he didn't have a PE in United Kingdom, it won't be taxed in UK. He alleged that it will be business profits because United Kingdom, for the domestic law purposes, treated qualified divers as business people. They believed that they drafted only for the purposes of domestic tax law, keeping in mind they wanted to give some incentives to the people, qualified divers, because at that time they believed that qualified divers, they spend more money out of their pocket. They weren't like employed, they were doing business only. So for that purposes they gave that incentive type so that they can claim their expenses. So the issue was between the UK, Mr. Fowler versus Her Majesty Revenue and Customs, that is HMRC, UK government. So South Africa government was not involved in this case. The ruling attempts to address that whether to what extent the treaty allows domestic deeming provision, because the UK government, as I said, contained a deeming provision that qualified divers would be treated as self-employed contractors and they would be treated as business profits. So can that deeming provision be affected? Can the deeming provision affect the treaty? Affect the meaning of the terms of the treaty? And to what extent the deeming provision amends the meaning of the terms of the treaty? So this is the fact of the case. As I said, he undertook diving engagements in the UK continental shelf, and UK tax law, the diving activities were treated as self-employed for income tax purposes. Whereas for treaty purposes, the terms not defined in the treaty needs to be understood as per the domestic tax law. So whether Article 7 or Article 14 would get attracted, and whether you would be taxed in UK or not. That was the issue. So the first trial tribunal, it went to first trial tribunal, upper trial tribunal, and HMRC, that is the Supreme Court of UK. So the first trial tribunal said that income from diving activities as income from trading, that is business and business profits. In India we say it as PGBP. And as a result, assessee's income has to be taxed as business profits, and it won't be taxed in UK since it didn't have a permanent establishment there. The upper tribunal, it went to the upper tribunal, it gives a contrary view, and he said it should come as employment and it should be taxed in UK. Then again it went to the Court of Appeal and they said that it should be taxed as business profits. And in the end, HMRC claimed that income which he earned from those dining activities, it should be taxed in the UK government, because it is employment. It is substance over form concept. He was actually employed. UK deeming provisions cannot apply and amend the treaty. So this was the assessees contended that section 15 of income tax trading and other income activities classifies the driving and the trading activities for all purposes under the UK income tax law, and therefore under the treaty as required by Article 2. Because Article 3(2) says that terms not defined in treaty, we can take recourse to the domestic tax law. So the actual earnings of Mr. Fowler must be regarded as profits, that is business receipts, which form a part of trading income. Therefore, Article 7 should apply rather than Article 14. So this was the contention of the assessee. Supreme Court held that we should come to the real world. We cannot apply a fictional deemed world and change the meanings of the treaties, because business enterprise this and all was defined in the treaty. We cannot come and amend the meaning of the terms of the treaty. We should understand the intention of the lawmaker. UK government made the law only for the domestic people. He didn't make the law keeping in mind the treaty. Whereas in treaty, it is the negotiation between two countries. The intention of both the countries involved needs to be understood. And two construction of those articles needs to be given. We cannot live in a fictional world, fictional deemed world which may be created by the UK income tax legislation only for the domestic tax purposes. They are to be applied in the real world. So this was the judgment of the Supreme Court, and the income was treated as employment and he was taxed in the UK. They also refer to Article 31 of the Vienna Convention, that in accordance with the ordinary meaning to be given to the terms. We need to give the ordinary meaning to the context and light of its object and purpose. We cannot, some deeming provisions of UK cannot deem a qualified diver as a business profits. We should come to the real world. The ordinary meaning needs to be given. So there are also other rules, other important points while interpreting a treaty, which also held that it should be contractual and statutory. It should be consistent with the compromises reached by the contracting states. The true intention of the parties need to be considered. So next is about preamble. That's all for today. We will continue in the upcoming sessions. Thank you all.